When you sentence my son, you are sentencing me. And emphasizing that she may very well not be alive if the judge were to give the harshest sentence of 30 years by the time her son completes that. Hearing this mother, she talks about her son's background, much like the defense did, that he gave 19 years of his life to public service, that he had a clean record. Mr. Barhoma, I want to ask you a question. I have heard some analysts say that clean record should be looked at with scrutiny because Mr. Chauvin benefited from an unfair criminal justice system, one in which police officers are not held accountable. And so he very well could have had a checkered past, which was not reflected in his record. What do you think?
That's hard to say. So, I mean, has he given 19 years of his life and be able to give back? That's one thing. How you categorize that and how you take it into respect, that's a whole other. Now, let me tell you this. On appeal, I really don't think that this judge is weary of getting overturned by giving a 22.5. I actually think that he's had the discretion to be able to issue this kind of sentence, and what he did is he weighed the factors as the fact finder or as the processor essentially in this phase, and he used his discretion to be able to issue that, and that's what's left for a judiciary. On appeal, the court's really just going to look at that and say, did he abuse his discretion? And ultimately, if we're going to appeal this to try and change the law and change the way that judges could use their discretion at this phase, then ultimately that's a different kind of question. But here, I think that ultimately these statements are necessary. The way that the judge takes it into consideration is necessary, and using his discretion is ultimately really what this ceremonial event is all about.